Okay, thank you, Sean, David, and Tom for the opening panel discussion, which is going to serve as the platform for the rest of the symposium. Our next panel is going to focus on the evolving U.S. treaty policy as reflected in the 2016 U.S. Model Treaty. The U.S. Model Treaty is the starting template for a U.S. Treasury to use when it negotiates or renegotiates income tax treaties with other nations. The 2016 U.S. Model Treaty includes several novel changes, and to the extent adopted in U.S. income tax treaties may make it more difficult for some business structures to qualify for treaty benefits as we move forward. This panel is going to be moderated by Professor David Rosenblum with panelists Peter Blessing, Jason Connery, and Quinn Huynh. Peter Blessing is a member of the Complex Transactions Group of KPMG's Washington National Tax Practice. Peter is a past chair of the tax section of the New York State Bar Association and was recently appointed president of the U.S. branch of the International Fiscal Association. Prior to joining KPMG, Peter was a partner with Sherman and Sterling for over 25 years. Jason Connery is a principal in the International Tax Group of KPMG's Washington National Tax Practice and is an alum of the Graduate Tax Program at NYU. Jason is co-author of The Current Status of U.S. Tax Treaties and International Tax Agreements, which is published monthly in the Tax Management International Journal. Quinn Huynh is an associate international tax counsel in the Office of International Tax Counsel at the United States Department of the Treasury. At Treasury, Quinn works on a variety of international tax matters with a particular focus on income tax treaties, withholding, information reporting, and FATCA. Quinn has taught courses as an adjunct professor at Georgetown University Law Center, where she earned her LLM. Professor Rosenblum, over to you.
All right, so we're going to talk about the new U.S. Model Treaty and where the policies reflected in it. If I can get this thing to work. Here we go. So I'm going to say a few words about U.S. treaty policy, very few words, and then I'm going to turn it over to Peter Blessing and Jason, who are going to ask some questions of Quinn. First of all, broadly speaking, the U.S. has got three things in its treaty policy that set it apart from other countries. We reduce tax at source in our model more than anybody, more than the OECD, so we're more favorable to the residence country in the competition between residence and source. And as part and parcel of that, and that's a long story which I won't go into, but it goes with that first policy that we're also a lot more sensitive to treaty shopping than most other countries. Some other countries are beginning to jump in and adopt LOB articles, but we've been there for probably close to 30 years now, and we're way out ahead of anything that appeared in BEPS on this. So that's the second big highlight of U.S. policy. And the third highlight of U.S. policy is that we limit benefits for U.S. persons using the saving clause, and we're very reluctant to use treaties to benefit U.S. persons. Those are the real highlights of the U.S. policy. I mean, we could talk more about federalism and not covering state taxes, but as I see it, those are the things that have us stand out. Now, we now have a new treaty, model treaty, 2016 model, which is, let's see, we started this business in 1975, so we had 75, 76, 81, 96, 2006, 2016, whatever number that is. So now we've got a new model, 2016 model. One of the questions that we probably won't get to today, but which is interesting, is what exactly are we dealing with here? Is this an ideal treaty? Is this the treaty we want to sign with everybody? Some would say yes. Is this a source of interpretative guidance with respect to existing treaties? Can one point to this model, which of course hasn't been enacted or gone through any legal process, it's just the brainchild of some people in the Treasury who put it out, can we point to that in terms of interpreting existing treaties? And there will be, I assume, Quinn will tell us about it, a technical explanation, and that'll give us, that just raises the same question. Are we going to have new material out there for interpreting existing treaties? Is this an expression of policy? I would say probably it is an expression of policy, but is it more than that? And then the question that I'm interested in is whether this is a model for the developed world only, or whether we approach the developing world with a different perspective. So those are the questions that I would, let me just say very broadly how I see this. Peter and Jason are going to focus largely on the headline items in this new model, particularly the changes to the limitation on benefits clause and some of the other special tax regimes, some of the other big issues in the model. I say that the model maintains the U.S. preference for residence-basis taxation. There's very little changes in that. There's some anti-treaty shopping rules in there, which are, I suppose, an incursion into residence-basis taxation to some extent. In other words, there's somewhat more taxation at source to curb treaty shopping. And in the LOB article, as the slide indicates, I think there's some real creative and emphatic effort to change limitation on benefits clause, which, by the way, is in all of our recent treaties, and I don't believe any two U.S. treaties are exactly the same in the LOB article. And this model has some very significant changes, which Peter and Jason will get into, going from the 2006 model. I think the most important thing, as you've already heard me on arbitration, I think the most important thing here is not simply that we are doing our mandatory arbitration, because we've already done that in 4 treaties in place and a couple of others that are pending in the Senate, but by putting it in the model, we're basically saying we would do mandatory arbitration with anybody, and that's significant. I had always thought we would be hesitant to do mandatory arbitration with countries with which we did not have an existing process for handling the MAP. So, I mean, if a country comes in and says, we like mandatory arbitration, even if we've never had competent authority discussions with them, we would be hard-pressed to deny that, I think, now that it's in the model. I think there are lots of little nuggets in the model, which we won't get into. We don't have time to get into, but there's a lot of little changes, word changes. There's paragraphs inserted in Article 13, the capital gain article has got an elective realization that's taken from some of our more recent treaties. I'm familiar with it in the Canadian treaty. There's a number of other nuggets of change in here. I would say there's not much change in substance, but my overriding thought, and I'll leave you with this thought, is that this, to me, this model is a much more US-centric articulation of a model than we've had. The history of the models in the United States, of treaty negotiation in the United States, was when we started this business way back, we tried to go to the rest of the world and negotiate on the basis of US law. That was a flop, because explaining US law to countries on a one-by-one basis took forever, and they were reluctant to sign on. And so what we did, and I guess I would have thought the takeoff point was probably the 1975 treaty with the United Kingdom. We said, the heck with it, we'll buy into what the OECD has done. So we adopted an awful lot of things in the OECD that we don't really totally understand, because it isn't our language. And we've been living with that now ever since '75. And this model still has plenty of OECD language in it. But there's a lot more US-specific language in it. My sense is that that's going to make it a harder document from which to negotiate it. We're going to have to spend more time explaining why something is in this model to countries that are used to the OECD and are not used to our domestic law rules. So that's all I got. Peter, I'm going to hand you I'm going to have Pete turn it over to Peter and Jason, and I'm going to observe like the rest of you.
Yeah, Jason's going to say something. He's going to say he's very happy that David isn't so pessimistic in this session. But go on.
Yeah, 2 things. So the 2016 model has grown to 70 pages versus 43 in 2006. And the other unique thing that happened prior to the release of the 2016 model is Treasury actually put out a draft model in May and asked for comments. And they actually read the comments and incorporated some of the changes into the 2016 model, which, as we'll go through, some are helpful to taxpayers.
Maybe while we're on comments, I'll ask Gwen whether she got any comments or whether the Treasury got any comments since they were due yesterday on the new model.
Well, as Peter indicated, when we released the 2016 model in February of this year, along with that, we also released a preamble to the model where we discussed some of the highlights of changes based on the fact that we had released in May of 2015 a draft of the proposed sort of new cloth provisions that we had. And one of the big changes that we had made was to the active trade or business test, and the fact that we are moving away from allowing active trades or businesses that are sort of in the same or substantially similar lines of businesses to qualify under active trade or business. And we had requested comments on the fact that we are now requiring a more factual connection with respect to the activity. Those comments were due yesterday, and we did not receive any comments describing fact patterns that people felt should be covered by an active trade or business test that is not adequately covered by any of the other LOB tests. And so maybe comments will come in late, but as of yesterday, we've not received any comments.
Everybody just loves it. So we're going to focus on the LOB article. We're going to ignore all the nuggets that David found because we weren't so sure how golden they were. But we're going to focus on the LOB article. And so this new model has some new provisions entirely and some pretty substantial revisions to some of the existing provisions. Because the headquarters test, for example, is, in our experience, so rarely usable, we're not even going to talk about it. And it's sort of interweaves in some of the other provisions and creates some complications, but we'll leave that to the side. The big news, of course, is the derivative benefits test being expanded, but they've also made substantial changes to the public trading test, and as Quinn just said, the active trade test. And so we're going to focus on basically those three provisions. First thing, though, I guess I would ask Quinn the question at the bottom of this screen, which is, given how complicated the new LOB is compared to the prior one, and given, or even the prior one was fairly complicated, but given the comments that Treasury and everyone else received in connection with BEPS, is this going to be easily negotiable in your view going forward?
Well, I mean, I don't want to suggest that any treaty negotiation is easy. I mean, even if you look at the 2006 model, people have said our 2016 has gotten a lot more complex, a lot more complicated, and I would not disagree that it's gone through some revisions, but 2006, wasn't a cakewalk either. No. And obviously, in a negotiation, you're sitting down and you are talking about these provisions. And so a lot of the LOB provisions, fortunately, are not cut from new cloth, unlike STR or subsequent changes in law. This is a provision that has been around. We've been applying a form of LOB since 1996. We revamped it in 2006. And the 2016 largely does build off of the 2006 framework and incorporates for example, the derivative benefits and headquarters provisions into it, which have added to the length of pages. So if people don't want to look at those LOB rules, if the old rules worked, you don't have to read derivative benefits and headquarters company. So the length of the treaty growing, I don't think is indicative of how much more complex it's grown. I think it's because we've actually added provisions that people have asked us to add for a number of years into the model itself with modifications based on what we've currently done. We have made that part of it potentially, on some ways, tighter, but in other ways, we've actually relaxed the 2006 model. So I don't, whether countries take it or not, I mean, when we sit down at the table, the U.S. has already said that we would not negotiate a PPT in the context especially of the multilateral instrument. And so our approach will be to sit down with jurisdictions bilaterally, probably to discuss a robust LOB approach.
Okay, thanks. So we're going to start with the public trading, the subsidiary of the public trading test, because that introduces some of the concepts, and it's got a new base erosion prong to it. First, we'll focus on the ownership test. So basically, this provision requires that 5 or fewer within a 12-month within a 12-month period of the time the payment is made have owned that it be a publicly traded company owned by 5 or fewer publicly traded companies. Sorry, the subsidiary itself has to meet a qualifying ownership test, a qualifying intermediary owner test. The qualifying, and I'll call it QIO because it's shorter. The QIO test has a sort of a very simplistic way to look at it. So anything from any company in the source country is okay, and any company that's in the residence country is okay for purposes of public trading. So mechanically, the way that works is the sub of the public trading test says source state is okay, QIO is okay, and then QIO itself says residence is okay, and third country is okay, provided they meet the STR, the special tax regime test, and the notional interest deduction test, and those provisions have to actually be in the treaty. And that last point is one I want to come back to here. So in this diagram, it's basically showing an Irish subsidiary that's trying to rely as a subsidiary of a public traded Irish company. So it's the Irish company is the tested company. There's a UK company in between, so that's the QIO issue, whether that's a qualified intermediary owner. And for that purpose, we have to not just look at whether there is a special tax regime or a notional interest deduction regime, but we have to see that there's a provision in the treaty. And I guess my first question to Quinn is, first of all, why is it so important that we have a QIO test in this chain? I've got a public traded company. The QIO test is only relevant to moving dividends up. Is it so important that the tax, whichever the tax, we've already protected the tax at the residence country, it's moving up as a dividend. There might be a CIV, but that's not typical in a public traded company. And in any event, we made policy decision about that. So we're moving up without, I don't understand. We could instead move it down, too, for that matter, into a different jurisdiction. So why is there the concern here? So that's.
I mean, I guess a little background is obviously that the intermediate ownership requirements themselves are not necessarily new in the 2016 model. They have been there even in '96 and in 2006. And so this was not actually a change in terms of limitation. And actually what we did in 2016 was to allow not only the source state to be an intermediate owner or the resident state, we've also now expanded it potentially to any other jurisdiction that has the STR and the NID. I mean, I think that when we go out there and negotiate these treaties, we do have an expectation that the income is being benefited and enjoyed by the treaty resident to which the income is entitled. The treaty benefits are entitled, and I think that we do have some concerns with respect to movements up the chain. I mean, down the chain, that's not something that we've had in the past, and as I had said, we were developing off the basis of 2006, and so it's an expansion, in fact, actually, of the 2006 model, and so I don't view this as narrowing. To the extent anyone was qualifying today, this is not going to be the reason why a new company or a structure is going to be disqualified.
Yeah, so I'm not going to let Quinn off the hook just by saying this is the way it was in the last treaty. I mean, we acknowledge that, and I meant to say that at the beginning, but we're sort of exploring the policy, and I still don't know what the policy is. But let's take that as a given. The provision does not say, like base erosion, that it's a problem if that intermediary owner is actually benefiting from a special tax regime. It's a problem if there's not a provision in the treaty. And I'm not sure why the difference between the base erosion test application of STR and the ownership test.
I mean, I'm sure you're not going to like my answer here either. But the reasons really for why we decided to have that as a requirement in the QIO in part was that we thought it was more as a technical and administrative matter, a lot easier for people to know exactly what kinds of intermediate owners will qualify by having it in the treaty. Also, the manner in which we modified the STR rules themselves to require jurisdictions to provide a notification and to talk to the other treaty partner, we thought also made more sense in the context of putting it into that treaty, that we would have the framework in which we could talk to the other treaty partner about sort of the regimes that are in place in that third country, in your example in the UK. And so those were some of the reasons for why we ultimately decided to keep in the requirement that the treaty itself have to include the STR and the NID provisions.
So how do you plan to deal with the transition when a lot of treaties don't have it and you're negotiating the first 5?
I mean, I definitely will acknowledge that as we get up there and start negotiating this, it will be slow to start in terms of putting in STR. It is something that we've asked to be put into the multilateral instrument, and we'll see where that work goes. But, you know, it will not, for example, take away anything that people were potentially qualifying under 2006. So this is a broadener to the rule, and it will be slow going if countries are slow to take on to STR. But it is something that we've proposed for the MLI work, and I don't know yet where that will ultimately land.
Yeah. To be fair, Quinn, except that you always say it's a broadener, which I like that word, by the way. It's more generous maybe in some ways because any third country was a problem before. But on the other hand, that's why the whole provision was a problem before, because it was too strict. And but going on to the next.
But just, I mean, on the timing issue, you saw that in the UK treaty when the UK treaty included a zero rate on dividends, and one of the ways to qualify was through the derivative benefits test. And Treasury acknowledged in the technical explanation that at the time it's not really meaningful because no other treaty had a zero rate. But over the next several years, you saw Netherlands, Germany, and several other countries include a zero rate, and now the derivative benefits for zero rate on dividends is generally applicable.
Okay, so now just looking at the base erosion prong of the sub of public traded test, of a publicly traded entity test. We have some new additions here. One of them is the you'll see in the second bullet that the connected persons cannot benefit from a special tax regime or national interest deduction. So that's what I just made reference to. That helps to shore up the base erosion. I grant you that's an important provision. And the other, which we'll come to on a later slide, is a tested group concept to prevent consolidation. And that's also a means of shoring up. So that makes a lot of sense. Notice, though, that in terms of who is a good payee under this provision, these provisions, and again, I grant you, all the recent treaties only refer, as for purposes of a good business entity payee, to a publicly traded company, not a sub of a publicly traded company, no other company. And we'll come to that as to whether that's really appropriate. Now, the base erosion test, of course, doesn't apply to dividends, presumably because dividends don't usually base erode, and in a publicly traded entity context, it's unlikely there's a REIT, but there could be CIVs, but there's special policy concern issues for that. So let's go to the gross income side of it. Here there is a change from the approach taken previously, as illustrated in a private ruling, where a participation exempted dividend did count as good income for purposes of the base erosion. Now this one I understand, but I'll let Quinn say why she thinks Treasury made this change.
Well, we made the change to exclude dividends from being included in gross income when the company is testing itself under Articles 11 or 12, for example, for interest or royalties. Largely in part because when you allow the exempt dividends to be included in gross income, it allows for more potential for base erosion because the amount that you can now base erode is increased by your gross income because it's normally capped at 50% of the gross income. And so with respect to income and dividends that were not subject to tax and were in fact exempt from the base, we decided with respect to interest and royalties, for example, that you should not be able to include that to bump up your gross income, which would allow you to effectively base erode more than.
Yeah.
So that was the policy reason for that change. I think it's fairly simplistic.
Right. So say say a company has a dividend of 51 from the U.S., it has 39 of other taxable income, and then the U.S. company also pays 10 of interest. So essentially, the foreign company now has 49 of taxable income, 51 of non-taxed income, and it pays an interest deduction of 49, and magically it's eroded 100% of its taxable income. I think that sort of makes some sense.
But I mean, there are other backstops, right? There's the conduit regs, so you just can't freely base erode to anyone. It's got to be to someone who is otherwise eligible for treaties at the equivalent rate. And then there's also sort of the beneficial ownership requirement.
I mean, the conduit point is fair. I mean, we had thought about that obviously in the context of looking at the LOB and sort of the update to the model itself. I mean, the conduit rules, though, apply transactionally, so you have to look at every sort of back-to-back financing arrangement. And if you do find a conduit, it's only with respect to those payments, whereas LOB certainly does have a broader effect because it disqualifies the entire company from treaty benefits by taking away the qualified person status of a subsidiary.
Let me just jump in with one point here. You mentioned beneficial ownership. Beneficial ownership is a problem under the existing model, and it's going to be a problem under this model too. And I would hope the technical explanation will deal with this more clearly than the existing technical explanation. The problem is that we have these concepts floating around in the treaty. We have derivation, which is paragraph 6 of Article 1. We have beneficial ownership, which is in the investment articles. We have, and the derivation, the country that gets to determine derivation is the country of residence. But beneficial ownership is a non-defined term, so that's determined by the country of source. So when you've got the two different countries determining the qualification for treaty benefits, that strikes me as a formula for problems. And the technical explanation in the 2006 tries to strong-arm those two, not, I think, entirely satisfactorily. It may be that that's possible, that it can be cleared up by the technical explanation, but it's a weird rule that you get to get treaty benefits if you derive the income and are the beneficial owner of the income, but the country of residence tells you whether you derive it, and the country of source tells you whether you're the beneficial owner. That's a strange situation. That's all I got to say.
Yeah. I would say that the derived by concept allows the country of residence to apply its own beneficial ownership regime. Essentially, at the end of the day, it's looking to whether there's an agency or something. We view beneficial ownership as, it's one of your examples. I think it's an example of what David just said earlier today on this session, that we have inherited these terms from the OECD model, and then we try to say, well, in our sense, yeah, we agree it means a nominee and agent, but we also think it means conduit situations, and we might even think it means economic substance. So getting back to the base erosion test, this tested group concept comes over in all of the, it permeates all of the base erosion provisions. And it's, like I said, to me it's very understandable. We'll look at this example. So it's covering not just consolidation regimes, but other fiscal unity regimes and group relief regimes. So they very carefully referred to the specific things they knew and then said any similar regime. If you're talking about a disregarded entity under the laws of the residence country, I don't think you even get to this provision. You just apply that rule. And a disregarded entity under the laws of a source country, say the U.S., would not be relevant here. So this is showing that, let's say it's Lux owns Lux, and they have a fiscal unity, or it's UK, and in UK are in a grouping, and they have group relief. They simply don't want it. Treasury simply didn't want it to be so easy to avoid the base erosion test. I think that's fair. Active trade is a sort of an interesting situation because this provision. And I'll say at the outset, we're going to have time for questions. I'm sure lots of people have questions on this. This provision was when it was first introduced, explained by Tricia Brown as the essentially safety valve. Don't worry about these other provisions being too tight. You can always rely on active trade. And now it's sort of just the opposite. We don't want you to rely on active trade. We've got very nice things like headquarters companies and derivative benefits, which, by the way, are very hard to use, but don't worry about that. So the active trade test is being changed from what essentially was any connection. I think of it as any connection, upstream, downstream, parallel businesses, and not even so parallel. They're not even the same business, but related businesses. So it just had to complement, and you looked at the economic environment to see if one sort of performed in sync with the other, and if it didn't, you looked to see if it performed out of sync with the other, and that was a hedge. Maybe that was good too. But it's very broad, and now there is supposed to be a direct connection. It's not connectedness, it's a connection, which to me sounds like dealings, and their examples are dealings. It's upstream or downstream. I mean, those are dealings between the manufacturer and the retailer, or the distributor and the retailer, and so forth. That's a big, big change. So I'll let, I don't know if, Gwen, you want to say anything about it? Maybe not, but.
The evolution, I guess, of where we landed, it sort of changed. I mean, in the May version, as you recall, one of the things that we've been talking about and discussing as a part of the OECD BEPS project in Action 6 was sort of highlighting some of the problems that other countries actually perceived with our active trader business. For example, allowing attribution or aggregation for some of the substantiality tests for active trader business. And when we started looking at the rules ourselves more closely, we were wondering to ourselves, if you have a flower shop in the Netherlands, for example, and you have flower shops in the United States, what about the fact that you have two similar lines of businesses that don't have anything to do with each other, except that you're both in the sort of flower shop business, and maybe it's a Singaporean parent that owns both flower shops? If they put the US underneath the Dutch flower company, they may be able to suddenly get dividends, interest, other income out of the United States that would not have been entitled to those benefits had they been paid, obviously, to a country to which we have no income tax treaty. So I think we went back and we started to wonder, well, what is it about that dividend or interest income coming out of the US to a Dutch flower company that makes it connected to the Netherlands? Grant you, there is a real business in the Netherlands. They are there is nexus in that country with respect to that flower shop business. But I think what we were concerned about really was the factual connection for the income that's coming out of the United States. And so in our first attempt, actually, in May, what we did was we started to remove sort of the ability for different lines of businesses to be attributed to each other, thinking that that would solve the financing companies shouldn't be able to get benefits just because they have an active trader business in a particular jurisdiction. And what a lot of people came back and told us was that actually all you've forced us to do is reorganize and put the US directly underneath the active company rather than having a holding company in the same jurisdiction. And so, I mean, it was both over and under inclusive on many levels, the approach we had in May. And so ultimately where we landed after having more discussions at OECD and also internally was that our real concern was really with the fact that the income that was being paid out of the United States was not factually connected to any activity or any income that was being generated in the resident state. And so we created a new word, emanates, for this purpose. It looks very much like the old 2006 model. And so the moment we decided that we were going to go after and try to require more of a nexus with the resident state, we also allowed attribution back with respect to substantiality tests. And so we realized that wasn't our problem. Our problem was just the connection with respect to the income out of the US. And that's what we actually went out and asked for comments on and didn't get any as of yesterday.
Yeah. Yeah, I would say on that last point that this, as Quinn said, the substantiality test harkens back to the old test. So it's the old test. And I would say, not that you didn't need it, that you recognize that the new test was too strict and it really didn't make sense to extend it to that. I have just a general problem going back to the theory of treaty shopping and the old genesis of treaty shopping, and going back to the Aiken cases. And we had shell companies where income was being run through them. Here you have companies that have very substantial presences, and I'm going to assume substantial, because if you tell me you're worried about ones that aren't substantial, that's your issue. But if it's substantial, you got a substantial presence in that country, why is that company treaty shopping? Why does it have to be so tightly tied to that? That's maybe it's a rhetorical question, because I know you've explained and we've got to move on. But
I mean, the other question that's going to come up in practice is how much of a factual connection can I sell 2% of my parents' products? That's just something we're going to have to grapple with over time. Okay. So now we're going to move to the new derivative benefits test. It's not necessarily new. Most of you have probably seen it because it appears, the 2016 model treaty is somewhat patterned off the test that appears in many of our treaties with member states of the EU, as well as Canada and Mexico as members or parties to NAFTA. Traditionally, it's been a three-prong test, an ownership prong, a base erosion prong, and a derivative prong. The derivative prong, the classic fact pattern was you had a French parent, Luxembourg subsidiary, with the Luxembourg subsidiary lending into the US. You ask, well, if France received interest directly, we had a treaty that provided a zero rate. If Luxembourg received it directly, there's a zero rate. So the fact that EU member states or members of EU member states ought to be able to freely move their capital around the EU, there's really no treaty shopping necessarily going on just from an absolute rate perspective, or at least a source state rate perspective. And then people started saying, well, what if I had US ownership along with my French parent? Well, the US doesn't have a treaty with itself, so how do I apply this derivative prong, this rate test? And so I think it was first in the UK treaty where they started defining, and we'll talk about what an equivalent beneficiary is, to capture sort of the classic example, France, Lux, lending into the US, as to capture sort of US ownership and saying a US publicly traded company would be a good owner for purposes of the ownership prong. And we'll see the 2016 model treaty says, yeah, the US can be a good owner, the source state can be a good owner, but only up to 25% in my example of the LuxCo. I don't know, Quinn, sort of the 25%, when the original draft came out, there was no tolerance, and so Treasury received comments saying, hey, the source state ought to be a good owner, and Treasury modified to say up to 25% is okay.
Yeah, I mean, I think, again, sort of looking at the genesis of derivative benefits and what it was trying to do, it really was trying to find another way for third country owners that would have qualified under their respective treaties with the United States to be able to qualify a derivative benefits company. And it wasn't so much about U.S. companies, U.S. publicly traded companies being able to qualify a foreign company in the derivative benefits jurisdiction. And so I do think that when we modified it, we relaxed, I don't want to say relaxed, depending on the treaties that you're basing it on. Based on the model, we did decide that we should allow some level of U.S. ownership, and 25% is where we landed. I mean, under ownership and base erosion, and I guess we allow up to a 50% because we only require a 50% resident ownership test. But the resident in the case of the ownership base erosion is in the same jurisdiction, whereas in derivative benefits, the 95% could be across any treaty jurisdiction where we have a treaty with them.
Right, so that's an important point. The derivative benefits test in the 2016 model treaty is no longer geographically limited to member states of the EU and parties to NAFTA. It's now going to cover, the issue typically comes up with Japan and Australia on a zero rate on dividends, since they're not parties to NAFTA or member states of the EU. The ownership prong requires 7 or fewer equivalent beneficiaries own 95% or more of the tested company. I'm not sure where the 7 or fewer came from, but that's been around since the derivative benefits first appeared, and nothing changed in the 2016 model. Sometimes that can be an issue where you have a family and the parents have children and then grandchildren, and sort of the founder wants to retain the voting power, but for estate tax purposes start moving some of the value to his or her children and grandchildren. And then, as we mentioned, the ownership prong really limits the use of a holding company structure because it requires each intermediate owner in the chain be a QIO. And as Peter mentioned, that definition is extremely limited. There's a base erosion prong similar to the ownership or the base erosion prong of the subsidiary of a publicly traded company test that Peter mentioned, except here, bad payees are non-equivalent beneficiaries or equivalent beneficiaries that satisfy the headquarters company test, or an equivalent beneficiary that's connected, so a related person that's benefiting from an STR or a notional interest deduction regime. The complexity arises in trying to figure out how to define an equivalent beneficiary. And again, it sort of breaks it up into three owners: the classic third country owner, which is outlined on this slide and contains the derivative test, the derivative prong test. The 2016 model treaty is extremely helpful. Under sort of the current derivative benefits test, if you flunk the derivative prong, then the tested company can't meet the test and you have to go look for another test. So the classic example is Italy or Spain owns France. France is lending into the US. Our treaties with Italy and Spain provide for positive withholding on interest, as opposed to France where it's zero. So in my fact pattern, France is giving a better answer from a treaty perspective. So under the current version of the test that appears in our existing treaties, the French company would flunk the derivative benefits test. It's a little complicated in the 2016 model because it's not in the LOB article itself or paragraph 4. You have to go to the interest, dividends, or royalties article to find it. But now it's basically saying, all right, we're going to do away with the cliff effect, and my tested company, so France in my example, will be entitled to the highest withholding tax rate based on its owners. So in my example with Italy, it would be 10%. I have an example in the slides where I have US Pubco owning 30%, Japan 35%, and UK 35% of my Dutch co. The US-Japan treaty provides for a 10% rate. My example was intended for Dutch co to flunk because US Pubco, as a resident of the source state, owns more than 25% of the vote and value of Dutch co. But if we were to change the facts and shift some of US Pubco's ownership over to Japan and UK, by doing away with the cliff effect, the Dutch company, I believe now, will qualify for a 10% rate on interest. So I don't know, Quinn, if you could comment on the taxpayer favorable movement.
Happy to. I mean, that was something that the removal of the so-called cliff effect for derivative benefits was something that a lot of people had come in on and had commented about, and so we did ultimately do it. And as you said, most of the questions I get is, where did you do it? Because they can't find it readily. They're looking at the LOB article to find it. And so when we were coming up with the rule, actually at one point we had thought about doing a blended rate among the UK and Japan in your example. And actually, as we drafted the rule and talked with our IRS colleagues, it turned out that it seemed a lot more complicated to sort of do a blending of rates based on the differences of the equivalent beneficiaries. And so the highest rate among the equivalent beneficiaries was where we landed.
Yeah, I think we have more. There are more slides in your materials, but I think our time is running short, so we want to open up the Q&A period. So if anyone has particular questions about the new model that they'd like to ask, we'll do our best. Do we have any questions in the audience? If there are no questions, we'll revert to the slides.
I'll prompt one. Well, I have a couple of things. Well, one going back to active trade. If you have the very same business, as I read it, your examples right now are, like I said, they're upstream, downstream. It's not the very same. But if you have the very same, wouldn't it be the most natural thing in the world for me to set up a holding company that has a subsidiary that's in the same business? Isn't that absolutely the only way I should do it? And why wouldn't I want to have them in a chain? I guess I could have them side by side and forego the treaty, but it seems odd. I'll just note that. And I guess the other thing that, just going to this equivalent beneficiary, or actually derivative benefits in general, The qualified intermediary owner is sort of weird the way it applies there I think from a U.S. policy standpoint when you have a source country. So if I had a Irish company owning a U.S. company owning a Dutch company, or no, let me say it this way. I have an Irish company owning a Dutch company owning a U.S. company. So my U.S. company is a source country. This says, I think the qualified intermediary owner here, for this purpose, unlike public trading, says that I can't pay to, the Netherlands is not a good qualifying intermediary owner if it has a special tax regime, unless there's a special, anti-special tax regime provision in the treaty between the US and the Netherlands. But why do we care? Because that's only going to work against us, I think, because we never have special tax regimes, at least we claim we don't. And so we're just, in that case, not making the Dutch company a good treaty resident. I don't see the advantage from our standpoint because I see it cutting against us more often. But I'll just say there are many things like that in these provisions that you have to think about how they work in different contexts. But maybe we have some questions now.
I was going to just note, I mean, I guess part of the history behind the derivative benefits test also when we went back and, there is a history to the fact that previously in all of our derivative benefits tests, I think, with the exception of Spain, we don't have any limitations on who can be an intermediate owner. And so right now it could be Caymans, it could be UK, it could be Ireland, it could be any jurisdiction. One of the things that we noted was that DB, the derivative benefits test, really grew out of the ownership base erosion test. And ownership base erosion in 2006, as we started to tighten sort of who could be an intermediate owner, we found ourselves in this awkward position where we've tightened it in ownership base erosion only to turn around and find the same company qualifying under derivative benefits because there was no limitation on an intermediate owner in our DB rules. And so when we were dealing with Spain, one of the things that we did try to do was sort of rein in some of the intermediate ownership by at least saying, we should have some parameters around this because the way that intermediate ownership is unbounded, it was leading to weird results where the intermediate jurisdictions would be in places where we would maybe want to have a treaty with them, and the appropriate way for treaty benefited income in that case to go to Brazil or to go to another jurisdiction would to be in fact have a treaty directly with the United States. All that said, around the same time that we were looking at all this, the OECD came around with their BEPS project, and we participated in that. And a lot of countries around the table said, we want a derivative benefits test. If you're going to have a robust LOB, it must be accompanied with a derivative benefits test, to which other jurisdictions said, well, we're not going to agree to a derivative benefits test if there aren't parameters around who could be an intermediate owner, because we think that treaty shopping happens when you have structures with intermediate owners in odd places. And so the US was not alone actually in worrying about intermediate ownership as is reflected in the OECD report. They came out and we came out with initially a very tight rule. We said the only intermediate owner, I think in the 2014 draft, could be another equivalent beneficiary. And we acknowledged that after that report came out, a lot of comments came in saying that's ridiculous because an equivalent beneficiary, as I think Jason noted, is limited. It's a publicly traded company, it's an individual, it's a tax exempt or another governmental entity. They would be an EB and not an intermediary, so you haven't done any broadening or tightening of the rule. It's too tight. And I think at the OECD, when we went back, the US was the first to acknowledge that requiring an intermediate owner to be an equivalent beneficiary was definitely too tight. And so we've sort of played around and moderated with those rules in the context of that work, but also in the context of looking at the US model. And so where we ultimately landed was actually, again, in the May version when we came out with the QIO, it had a rate comparison. It had a lot more bells and whistles to that rule. And so we have backed off of it. We haven't gotten rid of the requirement for that particular jurisdiction to have an STR or an NID. But again, I think part of the rationale there was that we liked the idea of having that framework in place with another treaty jurisdiction in order to facilitate conversations about the STR regime itself.
Well, thank you to the panelists, and thank you very much for your attention. I think with this concludes this session, and Larry is going to tell us our next step.
And thank you, Quinn, David, and Peter, and Jason.